Welcome. I'm Alex Novarese, Editor-in-Chief of Legal Business and the in-house lawyer magazine, and I'm here today to chair a debate on one of the key issues keeping General Counsel awake at night, data security. I'm here with three individuals to give us some insight, who I'll introduce. This is Stewart Roome, Global Head of Cybersecurity and Data Protection at PWC Legal. Also to my right is Raj Roy, Legal Director of Residential Energy at British Gas. And to my left is Tony Bland of the consulting group Change Harbour. It's a fast-moving area, so to kick us off, I'm going to ask Stewart to just give us the kind of Cliff Notes update on recent events and things you really need to know about as a General Counsel.
I think the key thing is that security issues are now perceived to be much more than an operational matter, a trust matter that is playing out in the context of litigation, civil litigation and regulatory litigation. So we've moved from this being a topic for geeks and for technicians, if you like, to being a mainstream legal problem for General Counsel. I think that's the key thing I want to emphasise. And connected to all of that, Alex, we've just had the adoption of the EU Cybersecurity Directive, which is going to build a new framework for cyber across the entirety of the EU. And we had the recent adoption of the EU General Data Protection Regulation as well. So what they're going to do is cast a very strong legal spotlight on failure cases through mandatory breach reporting. So we can imagine in only a few years' time, most General Counsel will be seeing in their in-trays on a daily basis incident reports coming in where they're going to have to make calls about whether to telephone the regulator and whether to let their customers know. So that's the picture I think we should start off with.
And what's the time frame that those two pieces of regulation are coming in?
So we'll see the General Data Protection Regulation in force in 2 years' time, less than 2 years now, May 2018. The Cyber Security Directive has got another 2-year run-up, so member states will have to adopt legislation. But for most organisations operating in the economy today, they won't want to build to a 2-year future. They're going to be dealing with breach issues today, and they're going to be judged on transparency issues today, regardless of the fact that the law may be a couple of years away. And we're seeing that right now in the regulatory cases. So if you had a breach and you told the Information Commissioner, he would give you credit for doing so, and conversely, if you didn't, he would regard that as an aggravating feature. So business practice and regulatory practice is already ahead of the legal legal runway.
Sure. Raj, how easy is it to keep in step with data protection rules at the moment?
Well, as Stewart says, the environment is changing very rapidly in front of us. And before I come to your question there, Alex, I think it's important to pick up Stewart's big theme, which is the risk environment is changing fundamentally. So if you're leading a legal function, actually what was once the preserve of techies and specialists now does become the legitimate concern of leaders of a legal and regulatory function. And that is exactly because, as Stewart said, get these things wrong and it goes directly to your organisation's reputation. And if you think about the fact that legal directors, general counsel are all in the business of managing and mitigating risk, this is now essentially a new and different form of risk that is on the horizon. And therefore, actually, things such as the new General Data Protection Regs or Cybersecurity Directive are things that all legal leaders should be taking into account very closely and managing. Now, in terms of the Data Protection Regulation, Cybersecurity Directive, your question about how difficult is it to stay in touch, there are any number of people who are busy giving you a plethora of information about it. I think one of the things that Stewart and I have talked about at length is that all of these new regulations are constructed through political compromise. And therefore, if you simply read the text and try and implement them, you will tie yourself up in knots. And so the key issue to understand is what really matters to your business. And most businesses now, if they're competing properly, are thinking more and more about technology and data because it gives them better insights into their customers, particularly B2C businesses. So once you start to understand the importance of data to you, you can actually then start to build a strategy around that. And once you've done that, you can actually look at these pieces of regulation, legislation, and decide how best to give effect to it. Because simply reading the rule book or the numerous articles that will come your way won't serve you very well. I think the starting point is actually to make some very basic inquiries of your own organisation, and actually General Counsel are very well placed to do that, because if you start from the position of managing risk, most of that particular cohort of individuals know what questions to ask.
Yeah.
And then you can start to overlay the key requirements of these pieces of legislation. But I mean, my answer to your question is there are 90, 100 plus provisions of the GDPR.
Yeah.
My advice to anyone in this field is not to try and read those and apply them in a really formalistic, rigid way, because A, your business won't thank you for it, fundamentally. B, your business won't buy into it, and therefore it will never actually get implemented. So your starting point is actually to think about it on a risk-based approach, to determine your framework, and then to see essentially how does your framework dovetail with those pieces of legislation.
So there's 99 provisions, what you're saying?
90 plus.
Two matter.
90 plus provisions, I would say. So what you have to do is understand the thrust of this regulation, or the directive. What is it intended to achieve? What is it fundamentally
Broad
about?
principles.
And then once you start from that perspective, you will be able to build a framework around that. Now, there will be some very specific provisions in all of them that you'll have to think about, but a lot of them are very, very ambiguous indeed. And the way in which you implement them is a matter for most organisations.
Sure.
So even if you think within the realms of technical and organisational security, you have international standards, ISOs, and there are ways of adhering to those. But it is then for each business to think about how you go about doing that, and delivering that. So yes, you can absolutely keep up to date, but my advice would be actually to start with your own analysis of your organisation. And use the kind of risk tools that you've probably got already in your armoury, because they'll equip you to actually handle regulation. If you start with the regs or the directive, you will struggle.
Sure.